而家係進行時。
We now elect the chairman of the subcommittee. The procedures are in Annex 4 of the House Rules. So any nomination for the chairman, one valid nomination should be made by one member and at least seconded by another member orally. And also the nominee will also accept the nomination. I nominate Mr. Andrew Leung, seconded by Mr. Martin Liao. Mr. Andrew Leung, do you accept the nomination? Yes, I do. Is there any other nomination? If not, then the chairman is Mr. Andrew Leung.
多謝各位同事嘅支持，咁就。
I thank members for your support. Let us invite the officials into the room. Before they come in, I have to declare interest. I'm a member of the Competition Commission. Is there a need to elect a vice chairman? May I welcome the Deputy Secretary and also the government officials and also representatives of the Commission. Carol, would you introduce the paper? Yes, thank you, Chairman. Good morning. I'm glad to attend today's subcommittee meeting and introduce to members 6 pieces of subsidiary legislation. The two regulations are submitted by the CDB and the other in relation to the competition by a tribunal and also the High Court rules are submitted by the Judiciary. First, I will speak on the competition fees regulation. This is formulated under under the competition ordinance. Application is dealing with the amount to be paid arising from application to the competition commission or for the performance of services, and also application to the CA, Communications Authority. Now we spell out that the fees to be charged include 3 of them. First, an application for a decision as to whether an agreement or conduct is excluded or exempt from the first or second conduct rule of the CO. B, an application for a decision as to whether a merger is or a proposed merger would be excluded. And C, an application for a decision as to whether to issue a block exemption order for a particular category agreement. The cap of the fees is decided by the Commission and the CA with reference to the fees and charges in Hong Kong and also similar services in overseas jurisdictions, and also the principle of cost recovery or user pay principle. The CA and the CC, Competition Commission, have made reference to the complexity of handling the case and the resources needed to deal with the cases. It also sets out that the Commission can also consider waiving, reducing, and refunding the amount paid under the variation under the communications ordinance, and the fees will be similar to that of the Communication Authority, and therefore it will be similar to that of Commission. Therefore, the fee will be similar, but it will not exceed the cap set by the regulation. On the 27th of April, the Commission The Competition Commission consulted the LegCo, and members do not have contrary view. Let me now turn to the 5 commencement notices. The commencement notice was formulated in 2012. The administration introduced the competition bill in phases. The administration, the Judiciary, and the Competition Commission have to be prepared, have to do the preparatory work before it commence operation. Now there is we have already set up the Competition Commission, the Tribunal. The administration is the view that the law can be implemented in 2015, December 2015. Therefore, there is the notice, which commencement notice, which designates the full implementation in December 15, 2015, and there are also the competition tribunal rules, competition tribunal fees rules, competition tribunal suitors funds rules, and also the rules of the High Court Amendment Rules 2015. The AJLS panel has been consulted in February, and also a subcommittee under the LegCo has also studied the rules, and the rules have been enacted under the negative vetting process in July this year. And the Judiciary has by and large completed its preparatory work for the operation of the competition ordinance. Therefore, we hope that on the 14th of December 2015, the law will come into effect in total. Thank you. Thank you. Any questions from members? Mr. Sin Chung Kai. Chairman, my question is in relation to the fees. Now, you say that you have taken into account the factors of cost recovery and also a comparison with other jurisdictions. But I have noticed that the amount is quite big. It seems that this is an anti-competition commission. Now, is there any room for downward revision of the fees? Now, you are in the starting stage, so to speak. Now, as for other commissions or committees in the past, they started with a lower fee and then later they catch up. So is the starting point too high? Thank you, Mr. Sin, for the question. With regard to the competition ordinance, there are clear guidelines and also conditions for exemptions and exclusions. The undertakings do not need to apply, and they already know the exemption conditions and exclusion conditions, and they enjoy these things automatically. But if the undertaking wants to know more clearly whether an agreement or a particular conduct is in compliance, and if they want certainty in terms of the law, there is a channel for the undertaking to apply to the Commission or to the CA. It is not a must with regard to such applications. In considering the fees, we take into account costs, and also we've made reference to the fees and charges of the competition authorities overseas. Now, as for SMEs, which may find the cost too high, then I think the members should consider the following points. With regard to the amounts we set out in the tables, in the schedule, they are the caps. So the actual costs depend on the nature of the case. As for SMEs, with regard to exemption and with regard to the guidelines, they don't need to apply first. They can consult the Competition Commission. The inquiries are free of charge. They can do it through the phones and through letters. There are also guidelines set out and examples are given by the Commission. The Commission also has discretion. Under some circumstances, taking into account the financial situation of the applicant and other factors, the Commission may exercise its discretion to reduce, to waive, or to refund.
I'd like to follow up. Well, if that is the case, then first of all, this is a new ordinance. We also have a lot of commencement dates. Actually, I'm not concerned about commencement dates. I support the enactment as soon as possible. But in the early days of enactment, it would inevitably raise a lot of questions. So, do we need to make an application? Some enterprises, in paragraph 4 of your paper, in paper number CITB 05/62, paragraph 4, it lists the fees. I'm worried that in the beginning, a lot of industries, they want to clarify the position. They might feel it's inadequate just to consult by phone. They might want to make an application, but in the face of some 50,000 or 100,000, some of them might be hesitant regarding whether they should make an application, even though this is just a ceiling. Of course, you have given the Competition Commission some powers. They can exempt some fees, but you only say you have to look at the applicant's background before any exemptions are given. So is there any room for you to lower the fees? And second, the Competition Commission, could you list what the exemptions are and how much can be exempted? If not, it gives us the impression that fees will be levied before the officials are even met with. So, well, if you just make a phone inquiry or a written inquiry, there's no fee involved. If you make an application, if you want an exemption, if you are breaking the competition rules and you need to make an application for with the Commission, this is something that is very important. So perhaps the Commission colleagues can clarify that. Thank you, Chairman and Mr. Sin. The competition ordinance is a new ordinance, and as a matter of fact, over the last year or two, the Commission has done a lot of work to help the industry understand the ordinance. I said that we had drafted 6 guidelines, including the first conduct and the second conduct guideline. We also have some case studies where the exemptions can be applied, and the Commission will conduct a lot of public announcements to help the public and industries understand the content of the ordinance. So now perhaps I'll defer to my colleagues, and could you also respond as why the fees are so high? So Competition Commission, you can respond to the consultation work you've done. Well, first of all, the Competition Commission, we had some education and publicity work. First of all, the Commission, the question is not about education and promotion. Could you respond to the fee issue? You had referred to exemptions. Do you have any formula or criteria for exemptions? Could you tell us, is there anything you can disclose in public? And could you tell us a formal application? Could you tell us what exemptions there are for formal applications?
The commencement of the ordinance, we will be publishing a guidance to industry on how to make the application, how to pay their fees, and we're also proposing to include in that some factors that we will take into account in deciding whether to waive fees or reduce or refund them. The factors that we will look at are the applicant's financial position, what the scope of their operations and what impact having to pay the fee would have on their ability to make an application. If they're a trade association, how the members have contributed or not to the fee, whether there's some other parties who are also parties to the conduct that should contribute to the fee, but probably most importantly, whether the benefit from this particular application in terms of creating a precedent for industry is so wide that it would be appropriate to waive the fee in relation to the particular applicant because there's a wider public benefit to come from the application. And I should stress that before anyone makes an application, we're encouraging them very strongly to come and talk to us first. We think in many cases industry's need for clarification won't actually have to go through the application route, that we can do something else in order to make it clear to them where they stand in relation to the exemptions.
Mr. Wang Dinggong, thank you, Chairman. Well, there are two sides to a coin. And of course, as Mr. Sin Zhongkai said, the relevant fees are expensive. But I've also heard the industry say that if there aren't significant fees, the mechanism might be abused. For example, SMEs, if people lodge complaints left and right and they need to respond to these complaints, it would take a lot of time. So I feel accepting the competition ordinance, before we accept any complaints regarding the competition ordinance, the Commission should have a procedure on whether they would accept a complaint, and then we can talk about fees. Now, would that be a better approach? Secretary? Thank you, Chairman. Thank you, Mr. Wang Dinggong, for the question. Well, on this occasion, we were talking about fees, and these fees are targeted at the industries where they have three issues: the first conduct, second conduct rule, or the merger rule, or the block exemption, and they wished the Commission to rule, and they would have to make an application. Now, just now we mentioned that in the first conduct rule, second conduct rule, under what conditions they can get exemptions. Well, the Commission will announce these through the guidelines and tell the industry where the exemptions lie. Now, the industry might still need some case examples where they can get exemptions. So the industry, under most circumstances, they do not need to make such an application to have the Commission make a ruling. All they need to do is refer to the guidelines, or they can consult with the Commission. So the Commission is is willing to meet face-to-face, over the phone, email, and explain to the industry the first conduct rule, second conduct rule, or exemption criteria. So we believe that under most circumstances, if the industry can resolve the questions through these consultation or free inquiries, they can get the answers. They don't need to make an application. As a matter of fact, making an application for the applicant or the Commission, it involves some costs. So the Commission encourages the industry to work with the guidelines, to understand the guidelines, and have some interactive discourse to understand the situation. Now, regarding the merger rules, you'll recall that it only applies to the telecom and broadcasting industry. There are no other industries that would be affected by the merger rule. Now, regarding the block exemptions, we're talking about some trade associations. We're not talking about individual companies that can get block exemptions. Well, Chairman, thank you for the Secretary's explanation. But the industry also has a concern, that is when SMEs face the competition ordinance, when it's being implemented in Hong Kong for the first time. So if they need to consult with the Competition Commission, their consultation, will it be legally binding? For example, the consultation results or outcomes, because they are afraid they misunderstand the consultation. And even if they don't misunderstand the content, they might have felt it, they were okay, but if they were prosecuted later, can they rely on the verbal consultation and use that as a defense? Secretary. Thank you, Chairman. Thank you, Mr. Wong. The purpose of consultation is to help clarify the ordinance for the industries, because the exemptions or first conduct, second conduct rule, that is already spelled very clearly in the ordinance. So we have some annexes that list the exemptions, but the industry might feel that if they just relied on the principal legislation, they might not be able to understand whether their behavior or actions would comply with these exemption criteria. So therefore, the Commission has compiled very detailed case studies, and it has also provided information where the exemption criteria can be applied. If the industry still feels confused, there is some free consultation they can get. They can conduct written email, or they can make phone calls and clarify with the Commission. Now, ultimately, an undertaking, whether they have contravened the competition ordinance, it depends on the behavior, the actions that were taken. We have to see if whether the spirit of the law was complied with. But I believe if we have the guidelines, and if given the free consultation plus other workshops and seminars provided to the industries, I think that the industries should be able to decide for themselves whether they have breached these ordinances, and they should be able to understand the criteria that are being applied. Thank you, Chairman. Regarding the fees, members might be quite worried about the way the fees are levied and when the fees will be levied. Just now, Mr. Sin asked about the fees paid to the Competition Commission. Well, aside from that, the CA, they can also exercise some powers of the Competition Commission. Now, if we look at the fee regulation, so aside from the CA, there are also fees payable to TELA, and the principle and the timing of the fees are also different. So if it's necessary, we can explain the details later. If I understand correctly, regarding when the applicant makes an application to the Competition Commission, they need to pay the fee as stipulated in the annex, but to the Competition Commission, they can exercise some discretion. Now, after the application is handled, they have this discretion to either lower the fee or refund the fee. So when they handle this application, if the fee is not as high as stated in the annex, then depending on how much it costs, they can have some discretion. But for the CA, there's another format. Now, if I understand correctly, the TELA authority, their fee basis is that when dealing with an application, the expenditure incurred, they have to recover these costs. They have to recover all the costs they incurred. But it is still, there's still a cap as set in the annex. There's a maximum, but they cannot exceed the maximum as listed in the schedule. But the Office of Communication Authority, they don't have the discretion to waive the fee. But if you're interested in whether they have discretion over the timing of the fee and how much fees, you can follow up later on. Secretary. Thank you, Chairman. Regarding the levying of the fees, the Communication Authority and the Competition Commission, they are separate entities. There is a trading fund for the executive arm of the CA, so they have to handle the fees according to the trading fund. The Communications Authority, even though they don't have a discretionary power, but the communication authority in dealing with the cases, the maximum fee is the same as the competition commission. They won't exceed a certain limit. In the competition commission, they will levy the fee when the application is made, and then they might they have discretion either to refund or reduce the fee. It's because when this new ordinance is enacted, we might have some potential applications, and if the competition commission needs to recover fees in the future, they might have to expend a lot of time or administrative effort. But in the communications authority, first of all, they have a trading fund, and second, the cases, the merger cases, and the cases they handle under the communications ordinance are similar, and it is a well-established mechanism, so they will continue to use this mechanism.
Now they have the same cap. As for the actual cost of handling the case, whether it is a CA or the commission, the fee or the charge will be according to the actual cost. Say if only $20,000 or $30,000 are spent on handling the case, then the CA or the commission will only charge the actual cost. Mr. Martin Liao. It's also a little bit of a follow-up to Mr. Wong's question concerning the cost. Now the tribunal rules, or the tribunal is trying to simplify the procedures so as to reduce cost. But there may be follow-on litigations. At the tribunal, both the prosecution and the defendant will have their team of lawyers. And sometimes not just the team of lawyers, but also accountants or statisticians or even economists in their whole litigation team or teams. The decision of the tribunal will affect subsequent litigations. So nobody will treat the litigation at the tribunal lightly. So they will have a big litigation team. So I believe the cost will be very high. And everybody knows that the loser will have to pay the costs of the winner. So it is rather prohibitive. Now, after operating the system for some time, will the administration or the authorities concerned consider the handling of costs? That is, each party will bear its own cost unless the litigation is malicious or it is a frivolous litigation. Under such circumstances, then the cost of the other party will be paid by the loser. Normally, it should be each bear its own cost. Mr. Liao, your question is not within the scope of these pieces of subsidiary legislation. I don't know whether the administration wants to answer the question. Well, that's in relation to paragraph 13, maybe. Yes, we have representatives from the Judiciary. Maybe they can answer your question. Now, at the start, we will adopt the normal approach in dealing with cost. Later, through our experience, we may need to consider many factors. The Judiciary has to deal with cases started by public bodies, and then there are also follow-on or subsequent litigations. So we need to consider whether similar cases will have to be treated the same. And we have to consider whether there is adequate justification for different cost arrangement, not just limited to the competition tribunal. At present, we have no intention to make the change. Mr. Liao, I hope the administration, in particular the judiciary, will consider this point. Now, there are many benefits under the common law, but the worst part of the common law is that it is very costly and the litigation time is very long. Even barristers who are in trouble cannot afford getting a barrister to represent themselves. Litigation cost has all along been a problem plaguing many common law jurisdictions. I hope that in the future, after the law is in operation for some time, the administration can carefully consider this, the judiciary. Now, the competition tribunal also allows unrepresented litigants. In the High Court, we have seen quite a substantial proportion of the cases are unrepresented. So that may help to reduce cost. Chairman, I am not happy with the answer given just now. At the start, I've already said that there will be subsequent litigations, and therefore, at the tribunal level, the litigants will not be unrepresented. When you are unrepresented, your counterparty the opposite side will have a big team, will still have a big team. I fully understand that you can be unrepresented in High Court cases, and many have done so because litigation cost is high. Litigation cost is high, and therefore people cannot afford getting legal representation. The situation of unrepresented litigants is something not desirable. It's not that people don't want, they just can't afford. Yes, so your view is very clear. Mr. Ho, thank you, Chairman. I have a question in respect of the point raised by the legal advisor. Section 3, Part 2. When an application is made to the Competition Commission, then the applicant will have to make the payment up front. That is, you need to put down a lump sum or a deposit. As said by the member before me, the cost will be very high because there will be a whole team of lawyers and experts. Now, for a big corporation or consortium, this amount of money is not big. But for small enterprises, when the when the small enterprise wants to proceed with litigation, that will be very costly. I think, Ms. Ho, I think you have misunderstood the point. This is not about litigation. This is about an application to the Commission to approve certain things, and then a fee will be incurred. So it will not be a SME. Usually it will be a big corporation which will ask for exemption from first conduct rule. This involves a lot of business interests. It's not what the situation you've said is not a kind of deposit. I say it's similar. I think 2 days ago we talked to the Judiciary at a subcommittee meeting on the deposit. I think the nature is similar. Before the case is completed, you have to pay upfront. Now you say at the end, you will only charge according to the actual cost incurred. If the actual cost incurred is less than the cap, then you will refund. That's according to the answer of the Deputy Secretary. But in considering the mode of charging the fee, have you considered that someone who cannot afford will not go through this process? The chairman said only the big consortium, or only the big consortia will apply, and therefore they don't have this financial problem. Can you confirm that small or medium-sized enterprises will not be affected? Yes. Thank you, Chairman, and thank you, Ms. Ho, for the question. With regard to the application, it is not a litigation, nor is it making a complaint. It's not the fee for making a complaint. It's about an applicant who wants to know whether his business agreement or the conduct is within exemption or exclusion of the first conduct rule, second conduct rule. He wants to know, he wants some certainty according to the law. Generally speaking, whether SMEs can fulfill the guidelines, whether their business falls within certain exemptions or exclusions. In fact, they can refer to the guidelines because they're all there. And we are also, the Commission is also willing to talk to them. They don't need to make an application. The SMEs don't need to make an application. If they don't know whether their business conduct or their agreement, business agreement falls within the law, the scope of the law, they can consult the Commission. The Commission is willing to provide assistance, and the trade is encouraged to communicate with the Commission before making an application. As for the SMEs at large, they don't need to make such an application specifically, and they don't need to pay the fee. The Commission is willing to provide free consultation to enable the trades to understand whether they comply with the competition rules and whether they fulfill the exemption conditions. As said by the representatives of the Commission will take into account the financial situation and the circumstances in giving a waiver. I want to ask the Deputy Secretary, in setting out these rules, you have consulted the business community. I believe you've done so. Is there any, or was there any voice of objection from the business community? Yes, the Deputy Secretary. The consultation was done by the Competition Commission with the business community. As far as I know, the business community understands that there's a fee, and they also want some discretion, and some also have spoken on the adjustment of fees. Maybe I'll refer to your question to the Commission. So who would like to answer the question? Ms. Webb.
We did conduct a consultation both before we came up with some guidelines about possible fees and afterwards. Most people in the business community understood the level of work that would be involved in dealing with such an application, and so they understood the need to charge a fee. Of course, most people would prefer a smaller fee than a larger one, but they understood the concept. They also made it clear that we should have the power to waive fees in particular cases, and as I mentioned before, we've certainly will be putting out some information to people about how they can have their fee waived, so they won't have to pay the full amount up front. They might be able to have a reduced or a waived fee if they really need to. But we've stressed to people that they should come and talk to us first before they do anything and before they make an application, so that we can talk to them about their particular situation and whether they really do need to make an application in their particular circumstance. If they do, whether they would qualify for some waiver or reduction, having regard to the amount of work that's likely to need to be done on the particular application.
主席啊，我相信嗰個即係事。
Chairman, meeting with smaller SMEs and consulting with them. This is very good, but I think some time should be spent on consultation on whether it could be further improved. I want to mention this ahead of time, and I would like them to come back to LegCo and report on the actual experience that they've encountered and whether there were problems that were outstanding. I think they've heard you. Do we have any other questions? Legal advisor? Thank you, Chairman. Regarding the Communication Authority and the Competition Commission, they have two different mechanisms. We'll have to ask members whether they accept this at the policy level, especially regarding the discretionary powers. The Competition Commission will issue guidelines on how they can reduce or waive fees. They will provide further guidelines, and some factors they will consider as our actual costs, the applicant's economic status, and but as I said just now, if you look at the Communications Authority, the Communication Authority, they do not have the discretionary power to reduce fees. So, if in fact how much expenditure they incur, they will charge that. So, if you make a similar application with the Competition Commission, they might have a lower fee because they have a discretion. But regarding the application to Communication Authority, they will definitely recover the costs incurred. Well, if we don't have any other questions, we can enter scrutiny of the bill. It's just commencement dates. We can just look at competition fees then, because the rest are just dates. Thank you, Chairman. The competition fees regulation, the commencement date will start with the Part 11 of the Competition Ordinance. So that means 14th of December 2015, this year. Please continue. The interpretation, it will define what the application is and what the fees are. And the Communication Authority and Competition Commission will each charge their own fees. So when we refer to Competition Commission, it does not include Communication Authority. Clause 3, it says the fee payable for the Commission, Part 1, are all the fees in the schedule must be paid, and Part 2, there will be a refund if the Commission declines to consider the application. And subclause 3, the Commission may, in its discretion, reduce, waive, or refund in whole or in part a fee payable or paid to the Commission. And Part 4, it says that the section has effect subject to Section 4. No problem. Please continue. Clause 4 deals with transferal of application between the Communication Authority. In Part A, the Commission is to refund to the applicant any fee paid under Section 3 for the application. So the Competition Commission will refund. And then B, it's as a supplement on that a fee will be payable as if the application were made to the Communication Authority. Clause 5, we have fees payable for applications to the Communication Authority. Subclause 1 says that for every specified application made to the Communications Authority for it to perform a function falling within Section 159 of the Ordinance, the applicant must pay a fee to the Communication Authority. Please continue. Subclause 2, the amount of the fee is equal to the costs and expenses incurred by the communication authority in making a decision on the specified application or in relation to the processing of the application, but must not exceed the specified amount. Subclause 3, on receipt of a notice given by the communications authority of the amount of the fee payable, the applicant must pay the fee to the communications authority. Okay. Subclause 4, it's the same as the communication authority. When the communication authority declines an application, they will not charge a fee. The last clause, subclause, when there's a transfer arrangement between the two authorities. Clause 6 deals with the transfer application. If the application made to the communication authority is transferred to the commission, competition commission, then the communication authority will not charge a fee. The applicant will have to pay according to the competition commission fees, levy regime. Any question from legal advisor? Okay, let's deal with the schedule then. Regarding the schedule, the first item, according to Section 9(1)A, and this refers to the first conduct rule, and the application of the first conduct rule of Section 1 of Schedule 1. These are related. It's to enhance economic efficiency, and the maximum is 100,000. In item 2, it's still related to first conduct rule, but it's not related to Schedule 1 applications, so the maximum here is 50,000. And if it is related to first conduct rule, and under the ordinance, if there are other exemption criteria requirements, and the maximum is also 50,000. And then we have the items listed in BCD. Please continue. The third item is related to Section 15. That is, the applicant wishes the Commission to issue a block exemption. This is related to first conduct rule. So the ceiling there is 500,000. Please continue. Item 4, according to Section 24 of the Ordinance, that is the second conduct rule. Under the second conduct rule, all the related exemptions items, the ceiling is 50,000. So it's listed under ABC. Please continue. The last item, item 5. According to Section 11 of Schedule 7, that is the merger rule, under the applications, whether they are application A or B, the fee ceiling is $500,000. Okay, thank you. That would conclude my presentation. Any questions? So, Secretary, you could perhaps give us a timetable. We need to report to the House Committee by 30th of October, and amendment deadline for the amendment to subsidiary legislation is on 4th of November. Date of council meeting is 11th of November. Do we need also public consultation? Well, thank you, everybody. This will conclude our scrutiny. Thank you, Chairman.